This evening we've got our first journalism slam. So make sure that you are back here this evening. There'll be drinks and food and all sorts of loveliness. And more importantly, it's going to be a sensational event. You're going to get to hear the stories behind the stories of journalists. And we've got some of our biggest journalist names coming to compete this evening. So that's this evening. And then tomorrow evening, there's a big announcement coming. And that'll be preceded by the fabulous Dan Corder, Mr. Beanie. So that's just a small little taster of what's to come. So to get us moving this morning, I'm going to invite Christy, who's going to be moderating this session. And then she's going to call up her panelists. And then there's going to be the loudest, rowdiest of cheers. Christy, over to you. Thank you.
I'm happy to stand here. Sorry. Okay. Good morning, everyone. Thank you, William, for that. I hope you're okay. Thank you for that lovely introduction. Today's panel is a really important one, and I think it's an incredible honor to be moderating this panel, not only because of the subject matter and how important it is for our constitutional democracy in this digital age, but also because each of the panelists I've had the privilege to work closely with. Also, we'll be touching on the Judicial Handbook on Navigating Online Harms, which MMA launched earlier this year, together with ALT Advisory, and one of the authors will also be speaking on the handbook, its practicalities, and how we can incorporate that into adjudicating online harms in courts. To start, I'd like to invite onto the stage Justice Stephen Majiedt. Justice Majiedt has served as a Justice of the Constitutional Court since 2019. He brings decades of judicial experience from the High Court as well as the Supreme Court of South Africa. He's the Chancellor at Sol Plaatje University as well as an honorary professor at the University of the Western Cape. Justice Majiedt has been recognized for his contributions to constitutional jurisprudence, human rights, equality, and for his leadership in advancing legal education and access to justice. Justice Majiedt also penned the landmark judgment of Mineral Sands versus Riddell, which explored strategic litigation against public participation for the very first time in South Africa. So we're really in for a treat to learn from his insights in that judgment and how he's able to have seen it through and how it's been implemented since 2024, I believe, when it was, or 23, I think, when the judgment was passed. So please welcome Justice Majiedt to the stage. Thank you, Judge. Yes, you can take a seat right there. Second, I'd like to introduce Nicole Fritz. Nicole is a human rights lawyer, policy advocate, civil society leader. She's known for her long-standing commitment to constitutionalism, social justice, as well as the rule of law. Nicole is currently the executive director of the Campaign for Free Expression, having led several prominent South African civil society and regional initiatives. She's worked extensively on issues of criminal justice, accountability, freedom of expression, and democratic justice, and regularly contributes to public discourse through commentary and analysis on legal and political developments. We're going to get some insights into a lot of the commentary that Nicole has published on this topic of online harms. So welcome to the stage, Nicole Fritz. Last but not least, we have Ms. Dehosse. Claire is an associate at ALT Advisory and Power and Associates Africa. Claire has contributed to strategic litigation and policy development aimed at mitigating online harms, including gender-based violence and the misuse of emerging technologies. Her legal research has supported efforts to safeguard policy, freedom of expression, access to information, and digital spaces. Claire is also my former office mate, and I dearly miss working with her, so it's such a joy to get to work with her today. Welcome, Claire. Thank you. As I mentioned, this session will touch on the Judicial Rights Handbook, and it both offers a legal and an ethical lens through which we can understand online harms, and I hope we can all, after this, take some time to read this handbook, because a lot of what we'll be discussing is informed by that handbook, and it touches as well as on privacy, digital freedom, dignity, as well as freedom of expression. And over this hour, we'll be exploring how the courts, civil society, as well as legal tools can come together to make it safer without diminishing our constitutional freedoms. As I wanted to invite Justice Majiedt to give us a bit of an introduction into your work on the space and how you see emergent technologies and digital developments and online harms coming through in the work of the courts as well as other courts, because as you sit at the highest court, you have this bird's eye view on how all of these intersectionalities impact the work of the courts. So please, Judge, please give us a bit of an introduction to that.
Hey, good morning. This is the closest I'll ever get to be on a stage at a theater. So thanks for the honor. Can I just say before I speak on the topic that I have a huge admiration for the work that the media in general are doing, especially NGOs like MMA and others. And you know, judges, particularly at our court, and the media have been accused of being captured. So as a fellow capturee, thank you for inviting me. We live in a different space in the world now. It's self-evident that truth is not what it used to be, reality is not what it used to be, and harm is not what it used to be. Excuse the use of the word, but harm has become far more harmful than when we grew up. And when I say we, I'm in the 60s, so I'm not talking to the younger people. So the landscape has self-evidently changed dramatically where it concerns online harms. And we as courts, but not only courts, but also the regulators, are challenged continuously to adapt to this changing legal and normal, other outside of law landscape. Doctrines like privacy and dignity and accountability in the digital sphere has taken on different dimensions. We used to see sporadic instances of online harassment and defamation and exploitation, but now it's become far more complex. Cyberbullying, non-consensual intimate imagery, doxing, data breaches, and algorithmic discrimination. And AI has just made it far worse when it became added. The problem with online harassment and online harms in particular, online harms in general and online harassment in particular, is that it disproportionately targets women, the LGBTQ plus persons and activists, and it is incessant. It is a drumbeat of harm beaten all the time, because effect is gained through repetition and continued harassment. You will be aware, I think, of the Botha versus Smith judgment of our court. Now, I didn't sit in that case. I think I was on long leave, or I may have been on sabbatical or excused for duties elsewhere. That case concerned the right to privacy, but it also concerned whether when you put something in the public space, consensually of your own volition, you can rely on the right to privacy when all of this is republished online. And it's an interesting judgment, and I commend it to you. But this case represents an important recognition that the architecture of the internet transforms the scope of exposure and the bounds of privacy, so that what is now required is a nuanced understanding, and we're talking about online publication now of private details, It requires a nuanced understanding of what is meant by reasonable expectations of privacy in an era where we live, where viral amplification is so rife and rampant, but also quick. And so when it comes to children and other categories of vulnerable people, the duty of care is self-evidently greater, and we must, as far as children is concerned, lay particular emphasis on the paramountcy of the best interests of the child that's protected in the Constitution. We know now that POPIA has been implemented, but the proof of the pudding is going to be in the eating. But we've already seen the information regulator moving swiftly to enforce. There was a fine of some 5 million rand in the Department of Justice 2 years ago, and the Department of Basic Education last year for breaching POPIA. So we'll see how this goes. But I think it's critical for us as the judiciary to track this enforcement climate. We've got to be able to align remedies that's available in the Constitution and also in the law outside of the Constitution, but subject to the Constitution. We've got to align those remedies with real-world compliance expectations, not only for POPIA, but all related statutes. I want to just say that moving globally, the World Economic Forum organizes online harms through a human rights lens across categories, including harassment, privacy or data abuses, hate, speech, incitement, algorithmic bias, extremism, and fraud. And let me be honest and say that, and quite frank about it, that we in the judiciary must keep in step with these rapid developments, and we've got to do more to keep up with this emerging global architecture. We know now that we have the Cybercrimes Act, POPIA, the Equality Act, PABUDA, the Hate Speech Act, and other instruments which as a statutory toolbox. But their efficacy is meaningless if judges and other decision makers and adjudicators do not interpret them so that there is real protection against online harms. We must treat digital harms as real and severe, serious harms. So, what is our role as a judiciary? It's not only adjudicative, but normative. Judgments help define, outside of what we call the ratio decidendi, which is the reason for the decision, which really is the decision of the case. Judges often make obiter dicta, which are just opinions said by the way. Those are not really binding on the courts. In fact, they are not binding on the courts, but they have some persuasive value. But the reasons for the decision is what is binding on all courts, the lower courts and our own court. But sometimes judges say something not only in obiter dicta, in other words in passing, but also in their reasoning, which shape how society sees where the court is at and where the court is arriving at. So what is the court saying to get to a particular outcome? And so through that reasoning, we shape normative standards, and we shape we shape interactions among those in and outside of the space, in other words, the entire public, especially as far as rights, fundamental rights like dignity, equality, privacy, free speech, and so on is concerned. In an environment where expression and communication is instantaneous and with it harm too, and it's a vast network. I want to just point to a few emerging and recurring risk patterns before I say what I think we should do, and to talk a little bit about the MMA's wonderful judicial handbook. I see the following emerging and recurring risk patterns: harassment as a network, swarming the internet, brigading and pile-ons. This is harm through an aggregate pattern, and there's a foreseeability of implication. The second one I see as a challenge and as a recurring risk is anonymity versus accountability. You know, the internet, especially the dark web, is able to be anonymous. And with anonymity comes a challenge to accountability. And so here, we have to be able to get tools that can assist us to strip this anonymity. Because cowards hide behind anonymity to defame and to harm and to infringe. And then thirdly, there's the collateral effects of moderation. Sometimes we mean well, but we apply the tools that we use to counter these harms. We use them inconsistently, and they create uncertainty, not only for the lawyers who have to advise their clients and fight their cases, but also for the victims themselves. And sometimes, inadvertently, and without meaning to do so, we do more harm than good. So I want to say that I looked through the judicial handbook, and I got a hard copy today. Thank you for that. It's a welcome, rich resource in this new, challenging, and ever-evolving field. There's been remarkable work done by MMA, and I'd like to commend them for it. And to say that, in the end, when they say this about the judiciary, in conclusion in the handbook, one can hardly quarrel with it, and I quote, "The role of the judiciary in addressing online harms is critical. Judges must be proactive in understanding and interpreting the complexities of online violence in ways that safeguard human rights while addressing the unique challenges posed by new technologies. Continuous learning and engagement with emerging trends, as well as adopting a human rights-based approach to online harms, is crucial. By fostering transparency, fairness, and accountability, the judiciary can play a key role in ensuring that justice is served in the digital age." Close quote. As I say, one can hardly have any quarrel with that. So, let me conclude, because I was told it's 10 minutes. Christy here used to be my law clerk, but I think the roles are reversed now. She's telling me what to do, and I can't tell her what to do. So let me stick to time before I get chucked away from this mic. I think we must be particularly descriptive when we name the harm. That's the first point of starting. We should call it doxing. We should call it targeted harassment. We should call it NCII. And then we must link it to the right that's infringed. Now, that may sound like a mechanical, dogmatic exercise, but I'll tell you why. The lawyers in the room and those who understand law will know that you've got to come to court, especially the constitutional challenge or case based on infringement of a right. You've got to infringe the harm linked to the right infringed, linked to the remedy or relief that you seek. So that's the first point. Secondly, we must see the pattern, identify the pattern. We must look beyond single posts on Instagram or Facebook or wherever, and look beyond it and see that there's actually a sustained pattern of conduct and network effects. Next, we must look for the best fit legal toolbox, Cybercrimes Act, the Hate Speech Act, the PUDA, and so on, or POPIA. But beyond these statutes, ladies and gentlemen, there's also room for parallel civil criminal remedies, which we must not underestimate. Of course, it will depend on the context and the facts. If, for example, we use linked to, for example, the hate speech as part B of an application, as part A, an interim interdict, to preserve the status quo, to stop the harm from continuing, pending the resolution in part B, which will be the main case. We must increasingly make use of them, and do not hesitate to invoke criminal remedies. You know, we've got a lot of problems in the criminal justice system, and I mean, there are ongoing commissions of inquiries and so on, which is very worrying about how top policemen are fighting with each other while they should be fighting crime. It leaves all of us vulnerable. I'm not talking only about online harms, but generally. The police's constitutional mandate is to protect all of us. But how do you protect people when you're fighting more with yourself than with those that you're supposed to protect? So it's important that we get the remedies for the rights infringed. And we are unfortunately dependent on this broken criminal justice system because the NPA has got its own challenges. And so let me just conclude by saying this. We've got to keep going as a media space, but also in the legal space, keeping up with developments and having info sessions and seminars and workshops like these. In the judicial sphere, for many years, I was on the council of the South African Judicial Education Institute. And every year we have ongoing workshops and seminars on areas of the law, not only for people who want to become judges, we call them aspirant judges. I used to run that course for about 10 years, but also for newly appointed judges, and more importantly for judges who have been on the bench for long, and the same with the magistrates. And Majiedt does an excellent job. But the one thing that we are lacking behind is we are not keeping up with technology, with AI, with cybercrime, and with online harms like this. And that is why I welcome the judicial handbook that's come out. My intention is to send it to Majiedt and to see how we can work it into the curriculum when next we have a seminar, and we usually have it in the court recesses next year, June, July. So, at the end, let me thank you for putting together this excellent program, Mr. Bird and the rest of MMA. And let me commend all of you here for continuing to fight the good fight. You know, in South Africa, we always up against something or someone or both. But for as long as the NGO sector and the media and the judiciary, by and large, keep on fighting this good fight, I remain an eternal optimist. I said at a seminar last week, South Africa is often bent and battered, but never broken and never extinguished. We're a very resilient people, and people in the media, and people in the NGO sector is what make this country great, is what keep that resilience going. And I thank you for that. Thank you.
Thank you, Judge, for opening with that and setting the scene. And while the courts continue to grapple with the rapid development of digital and online harms, we cannot be blind to the role that corporate platforms play in offering some sort of relief and support. And Nicole, I know you've written extensively about how platforms themselves can often make things worse rather than better. In a recent article, you wrote how Meta's failure to offer relief is a chilling reminder of the consequences of corporate neglect. Given that, do you think that our legal system or even public interest litigation can meaningfully hold big tech accountable when their platforms enable harm, or are we fighting this battle without them coming to the party? I'd also welcome your insights and reflections on Justice Majiett's introduction. So if you could answer that together, please.
Sure. Is this on? Great, thanks. Thanks very much to MMA for asking me to participate in this panel. It's a great privilege. And thank you, Justice Majiedt, for that really thought-provoking presentation. One of the things that I wanted to pick up on, I mean, we are in a complicated moment. As you've heard, I am the director of the Campaign for Free Expression. But I think that this moment asks us to really think about what we mean by free expression. And Justice Majiedt already pointed to the notion of accountability, of anonymity versus accountability. And we know that a lot of online harms are being perpetrated and are being able to be perpetrated because individuals or shadowy actors can hide behind sort of anonymous identities. Traditionally, free expression has protected anonymous speech, and there are many circumstances in which it is absolutely important to do so. So for whistleblowers, for instance, it is important that they be able to make disclosures without their identities being known. Generally, we all should be able to make comment outside of our identities associated with particular corporates or organizations. And so there is a kind of freedom that commentary behind an anonymous identity might allow. But that anonymous identity cannot be a cloak for abuse and for escaping accountability. And I think that is what is happening, and we're seeing that facilitated by the social media platforms, unfortunately. And we saw that in the recent Meta case, where in fact what became clear is that there had been no proper verification of the accounts that were opened and that were distributing school children's pornographic content. And when, in the face of a court order, they were required to provide those identities so that parents and the school children themselves could pursue justice, could pursue accountability, it seemed that the social media company in question had failed, in fact, to properly verify, to uphold its own policies. Justice Majiedt has also spoken about the various pieces of legislation that we have in this country that are seeking to address online harm, and that is important, absolutely. But what we are seeing is that the social media platforms, which are typically headquartered in the United States or in places like Ireland, are insisting that they don't recognize our legal regimes, right? They're, in fact, pretty contemptuous of our legal frameworks. They insist that they're foreign peregrinos, that they don't have to adhere to our laws. And it is absolutely essential, I think, that we make it clear through our laws that those who seek to profit from South Africans, who seek to make their services available here, to profit from advertising revenues, are bound by our laws and are held accountable by our courts. And so it is very important that this process, which is underway, spearheaded by the Department of Communications and Digital Technology, be supported. It has recently asked for comment on the third iteration of its white paper on audio and audiovisual media services and online safety. And I think particularly in respect of online safety, I mean, I know a number of organizations in this room. We at the Campaign for Free Expression, together with SANEF and the Press Council, under the rubric of the Free Expression Legal Network, have put submissions to the department as to how we are to compose a regulatory environment that ensures that social media companies are held accountable. At the same time, and here's where it's complicated, we want to absolutely ensure that they are held accountable for the harms that they facilitate or actively perpetuate. But we don't want to provide a backdoor by which there can be executive censorship. So the model that is being proposed, and I know that many others in the room, like MMA, endorse this, the idea of a co-regulatory system, which ensures that there is an independent regulator, that there is an online code of conduct, that social media platforms have to comply. Failure to comply would leave them open to liability before our courts. And so it's absolutely essential that we move forward with those processes and advocate for this law to be brought into effect. We know that the dangers are real now. Again, as Justice Majiedt pointed out, I think they are potentially accelerated by AI. And what does free expression mean in respect of AI? Are we going to grant free expression to, automated bots? I think they're real philosophical questions that we're going to have to grapple with. One of the other issues, obviously, is, and one of South Africa's most famous authors brought this to to public attention recently. Zakes Mda, Nadine Gordimer, various authors, work was used to train AI models in the US. They were able to secure remedy in the United States. But many creators, content creators here in South Africa, are currently without the means of redress. And we are also going to have to look to how we draft and enforce our laws to ensure that content creatives are getting remedies. We absolutely want AI models to be trained on content that is produced here, and I said this yesterday, because otherwise those AI models are just going to inscribe the biases, age-old biases, as we've seen with Musk's Grok. But we do not want those content creatives to be left without real remedy and redress for the use of that content. So there is another sphere where we are going to have to do a lot of work, and we have to move at pace because the dangers are here, but that requires really careful, close, considered work, but all of us in the room have to collaborate in order to ensure that it's done. Thank you.
Thank you, Nicole. This next one's for Claire. Claire, you would have heard when Judge was speaking about how the courts play an important role in setting a normative framing around the decisions and the reasons that are provided for each of the judgments. And one of the things that can support a court in doing so is providing the context necessary to each online harm. And I know that the handbook emphasizes the need for judicial sensitivity to context, and not just understanding the words online, but the broader digital ecosystem within which the harm exists. My question to you is, how can judges and lawyers practically apply context when making decisions to these cases involving online harm and misinformation? And also, please do share some nuggets that you took from judges' opening remarks that you'd like to take forward. Thank you, Claire.
Thank you so much. If I may, I would like to maybe just take one step back. I've brought with me an excerpt of some pleadings that were before the Gauteng High Court, where a survivor of NCI described the effect that the incident had on her. And I just want to read it out because I think it's really important for us to not get kind of lost in the technical jargon when we're speaking about these issues, but really remember the effect that these things have on people in real life. And just to give you a little bit of background, in this particular case, a person was in a relationship with a man, and he later went on to make a Facebook account under her name, invited her colleagues, her friends, her families to be friends with that profile, and then shared images and videos of her that she didn't know that he had filmed in the first place. Obviously, all of her colleagues and her friends and her family saw that. So this case was a damages case for infringement on her dignity, reputation, privacy. And here she describes how this has affected her. It happened in 2015. The judgment only was handed down late last year, so it's been going on for a long time. She says, "I have been unable to find closure. This is predominantly due to the type of harm that their conduct has caused me, particularly the effect that it had on my ability to form relationships with others. I'm scared to join any social media groups and meet new people in this way, whether in a social or professional context, because of the negative experience I have had. I am afraid of what others would think of me if they came across or even heard about the content posted on the fake Facebook profile. This has hindered my ability to interact with new people and network using these platforms. In everyday normal interactions, I need to have my guard up. I do not talk to people about my experience. I do not stay late at social gatherings, and I am scared when people want to include me in photographs. I'm scared that the defendants will find me and misuse those images." And I really want us to ground this conversation in that reality. This, of course, online harms affect people differently depending on what the harm is and the context of that harm. And this links to what Christy was saying earlier. When looking at online harm, so if we take online harassment as an example of that, we need to look beyond just the text of what is in a particular post or tweet or whatever it might be. Cultural and language nuance plays a really important role here. The example that is often given is the term necklacing, right? In the South African context, that means something very particular, whereas in, say, for example, in Europe, it doesn't have that same kind of very vivid meaning to it and violent meaning to it. And that is why a lot of platform content moderation fails in this respect, because whether it be a bot or someone, you know, working out of a European office, that word doesn't kind of have the same meaning as it would to you or I. So that's one factor that I think judiciary or other decision makers need to be really aware of, is the context of the victim or survivor, as well as the person who you know, was posting that message in the first place. And then also, Judge touched on briefly the network effects that a particular post or tweet may have. So when a person posts something, it will have a very different reach if they have 10 followers compared to if they have 10,000 followers. And the harm that is experienced by the victim or survivor is amplified depending on how many people may interact with that post or have seen that post in the first place. So that's something also to take note of. And then we look at, you know, a situation where a group is operating. We have recently had a lot of news coverage around Operation Dudula and the kind of harassment that they are spreading on social media. And at the moment, our law is quite individualistic in nature, so you would have to go after each individual person who may have posted or shared something, where it's actually a group and a coordinated effort, which may be targeting one person, or it may be targeting a group of people as well. So that context is also very important to take note of as well. Thank you.
Thank you, Claire. Carrying over the theme of context and the importance of understanding the disproportionate risks that certain groups face, Judge, you mentioned that we should prioritize the best interests of children when hearing cases of this nature, and like Claire's anecdote that she shared touched on the disproportional impact on women. When courts are applying principles of proportionality and the limitation analysis, how do you think the courts should weigh structural inequality like the ones we've touched on and the various impact, especially within our broader constitutional landscape?
Thank you. I'm going to answer that question, but I'd like also to just make a comment on what Ms. Fritz said earlier about these online media companies who are domiciled elsewhere outside South Africa. Can I just say that when you consider one of the most difficult cases, not most difficult, one of the more difficult categories of cases for me as a judge in the highest court are cases with competing rights. The right to free speech and the right to dignity. Kwelani is a typical example of balancing competing rights. So when you do a proportionality analysis and a justification analysis under Section 36 of the Constitution with competing rights where you find that the right has been infringed, then you would look at various subcategories of consideration that's been crystallized throughout the years, and the one first and foremost one for me is the nature of the right. So when you come to vulnerable groups like children and women and other vulnerable groups, I think the nature of the right must take a special importance when you do that analysis. So for me, that is the way to do it. Can I also say that I've spoken earlier about making use of civil law remedies outside of statutes where there's online harms. And I'm a proponent of an urgent prohibitory restraining order. Now the courts are reluctant to hear urgent cases. You can understand why. because people abuse the process to jump the queue, especially in busy divisions like Joburg, Pretoria, Cape Town, and so on. But I do believe that if you come with a case where there's a real vulnerable category of victim or complainant, like a woman in a relationship or a child, the court must look at urgency through another lens. Can I just then, I hope that answers the question, but can I just say something about what Ms. Fritz has said? We've got a particular challenge in this space now, and I'm going to just expand on it a little if you will permit me. When you think about online harms, Ms. Fritz is correct. Most of these huge media companies are domiciled in Silicon Valley, in San Francisco, or in Ireland. Ireland is very popular because of the corporate environment and the breaks that you get with tax and other regulatory matters. And so they feel that they are absolved from liability or they're immune because they are not subject to our jurisdiction. It's a huge challenge for us, not only in this sphere, but also in cybercrime. If you think about it, the servers are located elsewhere in India or in San Francisco or elsewhere, but the crime is perpetrated here. Jurisdiction is important for judges and for adjudicators because when you issue an order, when you grant relief, you must be able to enforce it. How do you enforce something against a company that is not domiciled here? I'm going to give you another example that's well known, that's been in the media recently. And I can't say too much because we're still busy with the judgment. You'll be aware that the competition tribunal, first the commission and then the tribunal, has been investigating the alleged currency manipulation of the rand. Now there's 28 banks from all over the world involved there. And the case is before us on a preliminary issue, the exact issue that we're grappling with also in this space, jurisdiction. Because you got some banks, international banks, that have branches or a local presence here. And I can't remember off the top of my head, but I think it's banks like HSBC and Citibank and so on of the US. But there are also other banks, and I speak under correction, I think Credit Suisse of Switzerland is one of them. It doesn't have a local branch here or any presence in the country. Others are easier. Investec, FNB, and so on, those are local branches. So we categorize them in local branches, local banks, sorry, what we call incula in law, and we categorize them as peregrini, those who are pure peregrini, that means they are strangers to the South African jurisdiction, strangers to the South African law system, and then the mixed bunch, foreign banks that have a local presence. The problem is this. Let's say at the end of all of this, we find that the rand has been manipulated. And I'll go into the details, the way these people worked it. But there's a pattern emerging, prima facie, on the face of it. But let's say at the end we found there's been currency manipulation, and then the Competition Act makes provision that you may impose a hefty fine on them. You talk about 10% of turnover, which is hundreds of millions of rands. But if a bank doesn't have a presence here, how do you enforce that order? Let's say it's a fine of 100 million rand. They're not here. You can't attach anything. You can't attach any assets, and so on. And this is a huge problem. It's a problem that we have in the online harm space with these companies that are domiciled elsewhere. I don't know what the answer is, but I think the courts will have to find a way of granting relief against these companies that, as Ms. Fritz says, just act as if they're completely immune to whatever is happening, where they're making vast amounts of money. It's no coincidence that the richest people in the world now are people who own tech companies. Thank you.
Thank you, Judge. My next question, both for Claire and Nicole, as you would have heard, Judge said that urgent relief and urgent interim protection orders are often warranted in these cases. And I wanted to hear from both of you, based off of your experience, how realistic is it to be able to obtain urgent relief or even an interim relief for online harms like harassment online? And what bottlenecks, if any, stand in the way of getting urgent relief for online harms?
Thank you. It's a tough question because I think it depends on the case itself. In recent experience in trying to obtain a protection order for online harassment, the bottlenecks there were that it took a really long time to try and explain to the judge why the tweets in question kind of met the mark of harassment, because of the things that we were speaking about earlier, the pattern of behavior, the context of the tweets, etc. So it took quite a lot of time for the magistrate to kind of understand the effects and how, the impact of an online harm can translate to offline risks and harms as well. So that was one thing. In that particular case, which, as I said, was a protection order, which, just for context for those of you who don't know, a person is supposed to be able to get a protection order without legal representation and quickly. Otherwise, it becomes kind of redundant, right, if the harm is allowed to continue for a protracted amount of time. That certainly wasn't our experience in that case. It took a lot of kind of explaining by legal representatives to get that across the line. And there as well, because the person who was tweeting was unrepresented, there was also obviously an imbalance of legal representation that the magistrate tried to balance by giving them a fair chance, which is fine and good. But that was also one aspect of why it took a long time. I think in other cases, maybe in a high court setting where urgent relief was required, there I think the issue that could come about, I haven't personally had this experience, but is again trying to make the connection as to why online harms must be acted against urgently. It's very easy to convince a judge of why, physical harms require urgent attention. I'm not sure if the whole of the judiciary is on the same page as to why online harms require equal protection and fast action. Nicole, I'm not sure if you want to add.
Thanks. Just to say, I'm not sure if you're talking about the protection order that was obtained. For me, there were circumstances when I was at the Helen Suzman Foundation and we were fighting the Zimbabwe exemption permit, and the staff and I in particular and my family were receiving various threats online, and we thought that it got to the point where in order to secure protection, I needed to secure a protection order, and I was incredibly fortunate in that I had the services of ALT Advisory, of Power and Associates available to me. Obviously, many people in the circumstances where they require a protection order are not going to be able to avail themselves of those types of resources. So I was incredibly fortunate, and yet, as Claire has said, it was an incredibly difficult, time-consuming, protracted process of going to obtain the interim and then final order, explaining to the judicial officer, the magistrate, why the harms which we presented were such that they warranted the grant of the protection order. And then I have to say, obviously what underlines the protection order is this idea that the police will assist. There is a suspended arrest warrant. And given my sort of previous interactions with the police, prior to obtaining the protection order, explaining to them why it was that I was reporting these cases, why I felt that police attention was warranted, and their utter sort of cluelessness and failure to understand, I think, concerned me as to, in the event that the protection order had to be actioned, would I receive the type of protection that was necessary. And as I say, I am very conscious that I had a very sort of privileged experience, as it were, of obtaining a protection order in those circumstances. And so, when I can only imagine what it is like for somebody without those circumstances, those fortunate circumstances. The other thing that I would say is just, again, in the case of this recent Meta case where we saw various perpetrators soliciting and then sharing pornographic content of school children on Instagram and WhatsApp accounts. There, in fact, a court order was obtained, and here, the court granted the order. You had various employees, representatives of that company, South African representatives here. You had an office. And so they made the order the order was that the content be removed, that the perpetrators behind the accounts be disabled from setting up further accounts to disseminate this content, and that the verifying information behind these accounts be provided to the legal representatives so that the families could pursue accountability and justice. And that was granted on the Monday evening. By Wednesday, there'd been very little compliance with that order. And in the face of that lack of compliance, there was then an application for a contempt of court order. And at the 11th hour, you then saw legal representatives of Meta coming to the party and looking to secure a settlement. I do think that contempt of court application order might have been an interesting positive development in our law, but given that the settlement was agreed upon, that was not in the offing. But there obviously is enormous difficulties, logistical difficulties, in securing these types of urgent actions.
Thank you both. Judge, in light of the challenges that Nicole and Claire have outlined with the judicial process, and not to put the weight of judicial efficiency on your shoulders, but do you see room, if any, for training within the judiciary to make sure that there is an increased responsiveness and a fast-moving nature to remedying these online harms? What room, if any, and how would that practically look like if we could change and upskill the judiciary to handle these cases more?
I think that's absolutely essential. So, because the magistrates, there are so many of them, there are a few thousand magistrates, they get trained on a regional basis, and I think we've got to include this in the curriculum, not only the substantive law as far as online harms is concerned, but also procedurally the need for urgent relief. And then the judges get trained centrally because they're fewer in numbers, and they get split up into newly appointed permanent judges of some service and aspirant judges. But can I just say that the challenge of the courts is, to an extent, especially for the superior courts, the high courts and Supreme Court of Appeal and the Constitutional Court, is that to an extent we're a victim. I won't say success because success is relative. We're a victim of what we've been able to achieve. So people have confidence in the courts and bring cases to the courts that shouldn't be there. I mean, we've seen so many political disputes ending up in the High Court and the SCA and the CC, which shouldn't be there, because people feel that they have to have the courts resolve their disputes, and also other cases. And increasingly, people also feel let down by government when it comes to the enforcement of fundamental human rights, more particularly socioeconomic rights. So they come to court increasingly and increasingly. And we're also seeing the magistrates' courts being swamped with cases because the courts are seen as being able to do something, a little bit at least, as opposed to people doing nothing, who are supposed to be doing what they should be doing. And so the problem is that the courts are grossly understaffed. We know that the morale in the magistracy is somewhat low, but there are magistrates, by and large, who do brilliant work under very trying circumstances. When you speak to magistrates, you hear that they don't have access to internet, they don't have even basic physical security, and they don't have proper courtrooms, and so on and so on. And so we have a huge challenge in this space. But I think we've got to start with training and awareness, that we make magistrates and judges, particularly those at the coalface, those of the courts of first instance, the court where the victims will go to first, the magistrates' court and the high court in the particular province, to make them aware of what real threat is posed by online harms. Because I think it was Claire that said, magistrates or a magistrate or a judge can understand the possibility of physical harm, but they don't understand that online harm can be even greater, perhaps, if you don't recognize the severity of that threat. Thank you.
Thank you, Judge. In closing, I'd like to ask each of you to share some of your reflections on what is one practical step that you think will make the biggest difference in ensuring safer online spaces and reduced harms.
It's quite a hard question because there are lots of things. I think digital literacy is really important. Of course, in this context, we are talking about the judiciary and their kind of understanding, but I think it's far broader than that. It's amongst children and the rest of society as well. I know MMA has recently done really good work, and if I'm not mistaken, it's the topic of one of the later panels around what effective digital literacy actually looks like. And I think that's really important. It must be done, kind of from the beginning of children's interactions with platforms and technologies, but it must continue throughout the rest of society as well, so that people are empowered to be able to participate meaningfully in online spaces, which provide a lot of opportunity, but to be able to do so safely.
Thank you. Nicole? Can I just give another shout out to the Judicial Handbook? I really think it is an excellent publication. So well done to MMA and to Alt Advisory. Having had a look at it, and this is, this is not necessarily the fault of the judges, but I mean, I see it with my own kids. I mean, there is just a wealth of difference in terms of their dexterity and ability to navigate sort of the online world versus mine. And I think, we want, within our bench, we want representativity across our society, but we also want maturity and wisdom. And so generally those who populate our bench are going to be sort of more senior and older. And at this point, they are going to be at some remove often from the online world. And so I thought the handbook was really excellent for explaining how these different social media platforms work and what their features are. I read a recent case that it was from the High Court, I believe, relating to a very senior, prominent politician who had brought a defamation claim, which he won. And I think it was right that he won. The content which he was aggrieved by was, I think, exceptionally harmful. But I was troubled because in this judgment, the judge refers to the fact that he has 3 million followers, suggesting, in a sense, that his dignity has been more aggrieved, more injured, because he has this large online following. And I think what wasn't reflected there, and look, the social media platforms are opaque, so we don't necessarily have credible data, but there have been umpteen studies which are showing that huge numbers of followers on these social media platforms, huge amounts of content that has been put on these online platforms is inauthentic content. It's been created by automated models, chatbots, and this idea that he authentically had 3 million followers, I think was, it's problematic that, this idea that you have more followers, therefore your dignity is going to be more impaired, I think is problematic. But the inability to interrogate this idea that 3 million followers was not, in fact, genuine, was not reflected in the judgment. And I thought that that was problematic. And so I do think handbooks such as this, which are looking to sort of educate the judiciary as to how these platforms genuinely work, is a tremendous initiative. So well done to MMA and to Alt Advisory. And then finally, as I said in my earlier submissions, I do think that we have a moment here that the Department of Communications and Digital Technologies has made available in the white paper process, and that we have to seize it, and we have to framework that is going to ensure online content for us all, but that is particularly conscious of protecting children and young people, given their developmental capacity. Thank you.
Nicole.
Yeah, so just tongue in cheek, I'm very worried because I got zilch Facebook followers because I'm not on Facebook for personal and security reasons. But you know, this thing of digital literacy is very important. I have 2 grandchildren now, 4 and 2, and that's what makes me hasten towards retirement. And the 2-year-old snuggles up when I'm working on the laptop and see my iPad there, then she will say, "Pa, are you my best friend?" And of course I must say yes. It's a leading question, and then she says, "Pa, in the next sentence, can I watch your iPad?" And so that dexterity, as opposed to, and I won't mention names, some of the judges, many of them, are almost digitally illiterate. And one colleague whose name I shall not disclose because she's a good friend, not in our court, mind you, in a high court, until very recently didn't know where to switch on a laptop. So there is a challenge, and I think we gotta overcome that. We also get IT training from time to time, but I don't think enough. I think the big point, and I want to echo what you said about the judicial handbook. I've already commended it, and I'm going to take it up with Majiedt to make it part of the curriculum for both the magistrates and the judges. But I think it's important that we emphasize to the judiciary, magistracy, and the judges to understand online harms for what it is. It's not something opaque, something up there in the cyberspace. It's real, it's here. It's harming our own children, our own societies. And you know, one of the worst things is for the judiciary to stay behind for those who must grant relief and effective relief, because the Constitution talks about effective relief where rights are infringed or threatened. And if we can't understand what the possible harm is, how are you going to understand what's the effective relief? And so I think education and literacy is absolutely paramount. And if one thing I take away from this session is how important it is that we get colleagues to understand the space that we're operating in now, and to understand that we've got to move ahead with the times and also with the threats that's facing us. Thank you.
Thank you, Judge. If we can give the panel a round of applause, please. Before you head off, sorry, I'd like to open the floor for 2 questions, if possible. Are there any questions? 2 brief questions, please. Please go first, and then we'll come to you.
Thank you very much. Just a brief comment. Is the handbook not also possible to be given to police? So just a comment there. But a question about the regulation of the global tech companies, and you know, to all on the panel. Is it possible to separate the economic impact from the sort of the social impact? Because there's been a lot of discussion, and correctly so, dealing with the online harms, but there's almost this idea, because we're living in a sort of you know, free market economy, that we can ignore the economic impact. And the truth is that the global tech companies have basically sucked out about 50% of all advertising from this country. They're competing with regulated media companies who have got a whole lot of obligations, etc. So should one be looking at these things separately, or is there a way of tying the two together because of the power that they exert? Thanks.
Thank you. We'll collect the last question for the panel. I know we're all dying to ask more questions, but...
Thank you. This question is for Claire. It is, yes. Sorry, just... you mentioned education. It's happening... Education is obviously where we start to curb a lot of harms on social media. It's easier to teach a child to do something than an adult when we're set in our ways. Growing up, when I was in school, we got taught critical thinking and reacting with empathy instead of just reacting, you know? So yes, you're angry, but why does it make you angry? And also, where is it coming from? It was a huge thing. My sister, we have a substantial age gap, 12 years. Mom and dad didn't know how to family plan whatsoever. When she went through the school system, there was no critical thinking courses, no empathy, like how to establish that. And she's now going into university, and I see that that's also been more or less removed from her courses. Do you think we should try and impress upon the education department that it doesn't have to be its own subject, but our favorite LO should maybe make a course or a lesson plan that emphasizes critical thinking, so that kids who are much more resilient and aware of social media than the rest of us don't just react, but they think before they react. And I see that happening a lot these days, coming out of the North America region. Even adults are just reacting instead of thinking before making decisions, and that decision is pressing the send button, essentially.
Thank you. Thank you for your questions. Should we start with the first question for the panel?
Just to say, I think it is absolutely imperative that we be conscious of the economic harms that have been created. And obviously, I mean, I'm speaking to a room full of media practitioners, and this is an industry that is in crisis because the economic incentives brought about by the online world have changed, advertising incentives radically. I've referred to these opportunities that we need to seize. We need to kind of craft a fit-for-purpose legal framework here that looks to ensure accountability for online platforms. That's about social harms, but also about economic harms. But I should also say, I mean, as a country, we're doing pretty well, I think, to try and respond to some of those economic harms. I think we're seeing across the world the assault on established media because of the withdrawal of advertising revenues. But I think we need to recognize that in our country especially, and Justice Majiedt referred to the disclosures that we're seeing, which it's terrifying that our most senior police are fighting amongst themselves. And it is absolutely essential that we be able to have independent, credible scrutiny and information provided, and the media is that body that provides it in the first instance. And so it is absolutely imperative that we look to preserve our media. But I think about an initiative before that the Competition Commission is undertaking at the moment, which is looking at these types of harms. It has already issued an interim report, which is very substantial and comprehensive. It is in the process of issuing a final report. And I think that will be a really significant development as to how we look to address that. And so I wouldn't want to create the impression that we're not responding to those threats. We absolutely are.
Just quickly, I know Mr. Bird is worried about time. So I think you're absolutely right, but the problem is, how do you do it? I'm just going to cite one example to you. We're busy considering the constitutional challenges to the copyright bill. Now, there are vested interests there, as you'll understand. People want access to copyrighted material, but the publishers and the copyright holders are protecting that. And so one of the things that was argued strenuously by some of the latter group is that there are certain international agreements that South Africa's got to adhere to, the Berne Convention, the TRIPS agreement, and so on. So you got to allow these companies their space for international competition, but you also got to balance the scales as far as our own interest is concerned in the media space with advertising and so on. Thank you.
Thank you, Judge.
So just to note on your question about the police, absolutely. MMA is busy developing a similar handbook directed at the police. They are often kind of the first points of contact for victims and survivors in reporting online harms that are crimes, so I think it's essential. In response to your question, in short, absolutely. So Pakamile, who from MMA, who works with the Article 12 and Web Rangers program, has seen amazing results in the children that they work with's ability to think critically, and these skills translate into, you know, being able to navigate online spaces, but also into other aspects of their lives. And I think it's so important. The more children that have access to that type of education, the better. So, absolutely.
Thank you. Can we give our panel a warm round of applause? This has been incredible. Thank you.
Right, well, they look pretty and famous for the pictures, and get a thank you token of gifts. You can, clocking it, yeah, there you go. What's this, huh? Who in the room knows what this is? Okay, the youths know. I didn't know what that was because I'm the elder. Thank you so much, everyone. I thought that was a sensational way to kick off the day. Thank you so much, Justice, for being with us this morning. Thank you, Claire and Nicole, and thank you, Christy, for a fabulous job of moderating. We're now going to move on swiftly to our next panel. And I think they're all in the room, at least I hope they are. But I'm going to invite up the moderator for our next panel. I think I saw a moment ago. Oh, there you are. Kavisha, yesterday you saw her bouncing around with the red and green paddles. Today she's got a slightly more formal role in terms of moderating. But again, this is going to be another fabulous discussion looking at slaps and the weaponization of law. And I will allow her to introduce both the guests, but they can come on board to the stage now. And some of them you'll recognize from TV and the like.